Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Starosiak in the studio with the heavy hitters today. We've got Robert Capovilla and Sean Flood. Sean, nice to see you. You've been on the podcast before, but not that much.
I feel like it's been like a year. My episodes don't make it sometimes.
You end up on the cutting room floor, do you?
I think so.
I don't think that's your fault, though. I think there's been some craziness in some of the episodes, but that's not due to you, right?
I think everybody has to one-up me.
Yeah.
So it gets a little crazy.
No, I can definitively say that the episode you're talking about was not cut because anybody was one-upping you. It was because Mickey Williams went off the rails and talking about his craziest cases, and we try to keep our content PG-13 at the most. That's why that episode got cut.
Yeah. Well, that happens sometimes in the media business, but it's great to be with you guys back in the studio. We've done a lot of podcasts this year, but it's been a minute since we've been in. So great to be with everybody. Great to have our listeners on board. We've got a great topic today. We're going to talk about sexual harassment cases. We've got Sean, who's kind of the resident expert at the firm, who's going to give some great insights on the issue. But before we do that, let's do a little pre-show question. And I'm going to put some parameters out there, which, of course, Robert Capovilla never likes to follow, but I'm going to put them out there. We are very close to an election, a very large election in this country. So we're not going to talk politics. We're not going to talk about who you want to win or why or what you agree with or what you don't agree with. I simply want to get you guys on record with a prediction as to who the president is on January 21st, 2025. And I'll defer to you, Sean, since you're not on the show as much as Rob and I. Let's get your prediction. Who is the next president of the United States?
First, I hate being wrong, so I'm going to go outside the box and say something crazy happens. And so it's I will say Senator Chuck Grassley will be president in January 2025. He's the Senator pro tempore, so I think that's who it's going to be.
All right, so he's fourth in line or something?
It's the Speaker of the House, but they're not going to elect him. Because I think of the way it's going to go, is there a chance, there's legitimate chance it goes 269. So then it goes to the House, and then then it goes to a runoff where each state gets one vote, I think. And then they make a determination.
I think it goes right to the House.
Yeah, and then each state gets one vote.
Yeah, and then the VP, I think, the vice president, right, has the...
All I'm basing this off of is when I saw the TV show Veep, which is very apropos, I guess. But
I did just read about this, and I can't remember what I read about it, but they do think
some
it's
real history scholars, government history scholars here.
I will either say it's going to be one of the VP candidates. So it's either going to be Waltz or J.D. Vance, Senator and Governor Waltz, or I'm going to say it's Senator Chuck Grassley.
Well, that's one I did not expect. I mean, I expected all kinds of different things. But
this is just a weird election cycle. Everything is getting weirder and weirder and weirder. My prediction is it's not going to be Harris or Trump.
Okay, well, that's very interesting.
I don't think that's happened since Rutherford B. Hayes. And that's a famous election. I believe I've got my historical figure right because that was the election that ended Reconstruction. The Republicans essentially brokered a deal that said, okay, if we get our guy, we'll stop the Reconstruction parameters that were put in place by President U.S. Grant. And I think that's the last time we had a tiebreaker go. I think it goes to the House.
Yeah, it definitely goes to the House. Who did Rutherford B. Hayes beat?
I can't remember the name of the guy. It's a guy that you wouldn't. It's a guy that most folks don't know. But
is it Samuel Tilden?
It may have been. I wouldn't even know. I know Samuel Tilden's a historical figure, but I wouldn't even know the name if I heard it. I just know that from the context of I'm a big Civil War guy, and the end of Reconstruction is oftentimes considered the election of Rutherford B. Hayes.
All right. Well, let's get your prediction on record. So you've got Grassley. That's. I'm still having a hard time getting my head around that, but I like it. I like something out of the box because if it were to happen to come true, we'd have it captured here on this recording. But
I think Donald Trump is going to win the Electoral College. I don't think it's going to be all that close. I think he's going to win Pennsylvania. I think he's going to win North Carolina. I think he's going to win Georgia. I think he's going to win Nevada. I think there's a decent shot he wins Wisconsin. And I think the diabolical state of Michigan will do what Michigan people always do, which is make the wrong choice. So I think he loses Michigan.
All right. Well, I think it's going to be Kamala is my prediction, that it's going to be her. Very close, but it will be her. So I guess we'll see what happens. This recording will obviously come out after the election, but we're a few days in front of it.
The real clear polling folks who keep track of all the main state polls have Trump at 288 or 290 electoral votes right now, but it is very close.
Of course, they had Hillary way up too.
Well, they had Hillary, but the thing about the historical numbers are they had Biden up by an average of 6.5% in the battleground states, and Trump did much, much better, and they had Hillary up by like an average of over 7%. So
what you're saying is Trump is always behind on these polls, and the fact that he's up in them now should say something.
I think so, unless they figured out how to actually poll Donald Trump. But that's what I think.
So the mayor's polls that came out today, which is we're about 4 days before the election, or I think Pennsylvania, Wisconsin, and Michigan have Harris up +2, and that poll is traditionally in favor of Trump about 60% of the time.
Interesting.
So that's an outlier, but I've been following the Nate Silver stuff on X, so very, very interesting. It's going to be close is the only prediction that people have.
I think that's probably right, because just in my little anecdotal talking to people, I mean, I don't have any problem finding people that are really, really excited about one or the other, hate one or the other. So I think it's going to be close, and that's why I think Kamala is my pick. I think it's going to be close, and I think she'll squeak it out.
That mayor's poll, though, is the only poll that shows her up in Pennsylvania at all of the 5 or 6 major polls in the last week. Every other one's got him up 2 or 3%.
All right, guys. Well, that was entertaining. Hopefully everything will work out for the best. We'll keep our fingers crossed. All right. So we're talking about sexual harassment cases in the military today. Rob, I think you're going to kind of take the lead on this and pepper Mr. Flood here with some questions, and Sean will share his insight with us. So looking forward to a great show.
Yeah, so I've asked Sean to join us. For those who don't know, Sean is a partner at Capovilla Williams. He's been with us from nearly the beginning. And Sean and I and Mickey go all the way back to our active duty days, where we sort of formed a trio back then of defense lawyers. And the reason I have asked Sean to come on and talk about sexual harassment is because I don't know of another attorney, quite frankly, military attorney in the country that knows it better than he does. And that has had better results than he has had. And just a little bit of background, Sean was a judge advocate in the Army, like Mickey and I were. Sean spent a long time as an operational attorney in the special operations community, deployed several times. And in that role, he also has a tremendous background in administrative law, advised a lot of high-level commanders. He was also a TDS attorney, and at one time was considered the best TDS attorney in the region, and that included a region that included Mickey and I. So he's got a long background in advising commanders and helping soldiers and defending soldiers, and he's got a very, very long, prestigious background in administrative law. And sexual harassment is kind of one of those areas that includes both administrative law and also court martials. And so for those that don't know, Sean is the only attorney that I know of that has actually won multiple sexual harassment court martials. So that's why I've asked him to come on the show. And what we're going to do is we're going to have Sean talk a little bit about what sexual harassment is, the actual definition, because I feel there's a major disconnect right now in the military where investigating officers and even some attorneys seem to think that everything is sexual harassment. I oftentimes joke that you could walk by another soldier and pass gas and they would think that's sexual harassment. And I say that because I've actually had that conversation with an investigating officer, so I'm not making that up. And so I think it's important for our listeners to understand, what does the law actually say? Number one. And then number two, we're going to talk a little bit about Sean's experience litigating these cases. And then Sean's going to give, 3, 4, 5 best kind of practices moving forward for how to protect and defend soldiers, Marines, airmen, sailors who are accused of sexual harassment. So, Sean, without further ado, give us a general understanding of what is the current definition of sexual harassment as it applies to our military members.
Thanks, Rob. So there's two sources of law for sexual harassment. One is out of Article 134 of the Uniform Code of Military Justice, which is applies to every service member after 26 January of 2022. So if you commit an act of sexual harassment or alleged to commit an act after that point, Article 134 of the UCMJ applies. And then there's 10 USC 1561, and that is the federal authority for sexual harassment and providing what a definition of sexual harassment is. And, for the purpose of this discussion, I'm going to be using AR 600-20, Army Regulations 600-20, Chapter 7, because that incorporates generally what the guidance is. And this all flows from DOD guidance on what sexual harassment is. But generally, under 10 USC 1561, it means conduct that involves unwelcome sexual advances, request for sexual favors, deliberate or repeated offensive comments or gestures of a sexual nature when submission to such conduct is made either explicitly or implicitly a term of condition or of a person's job, pay, or career. So we call quid quo pro, this for that. Pretty rare. Or submission to or rejection of such conduct by a person is used as a basis for career or employment decisions affecting that person, or such conduct that has a purpose of or effect of unreasonably interfering with an individual's work performance or creates an intimidating, hostile, or offensive working environment, and is so severe or pervasive that a reasonable person would perceive, and the victim does perceive, the environment as hostile or offensive. And then that's part one. And then part two is any use or connotation by any person in a supervisory or command position or of any form of sexual behavior to control, influence, or affect the pay, career, or job of a member of the armed forces, civilian employee of the DOD, any deliberate or repeated unwelcome verbal comment or gesture of a sexual nature by any member of the armed forces or civilian employee of the DOD. So that last one is incredibly broad, and that can be anything. But what it really comes down to, and what I see, and we'll get in this a little bit later, is people will just pick one of those. And this is Chapter 7-7 of AR 600-20. They'll pick one of those. Like, well, that's a repeated unwelcome verbal comment of a sexual nature, and he's a member of the armed forces, so that's sexual harassment. Well, no, you can't stop there. You have to read the entire thing. So 7-7, all of it applies. So what it really comes down to, it needs to go into these one of two categories, which is quid quo pro or hostile work environment. And there's different types of sexual harassment. There's verbal, there's nonverbal, and physical contact. And that kind of makes sense. Like there's actual saying the words that are of a sexual nature or sexual innuendo. There's nonverbal, which is gestures, touching on the shoulders, those types of things. And then, nonverbal is blowing kisses, making physical gestures. And then there's physical contact, which is the touching of the shoulders. And then if you're touching buttocks or the breast, that's obviously abusive sexual contact as well, which is, it's not going to be administrative at that point. It's going to be CID or OSI or NCIS jurisdiction. And then the quid quo pro, which is this for that, which is you give this for me, I'll do that. Every once in a while you'll see it. But most of it is what this idea was called a hostile work environment.
I'm obviously very familiar with the definition, and I always laugh, and I know Matt gave me a look, and he laughed too. When you actually read the Army's definition of sexual harassment, it is no wonder that the IOs, who are the officers that are investigating on behalf of the command allegations of sexual harassment, it's no wonder they get so confused. And honestly, it's no wonder that most of the new judge advocates who are serving in an administrative law role, which was my first role as a judge advocate, are also getting confused on what sexual harassment is, because that's about as convoluted of a definition as there possibly could be. And so, Sean, just for the E5 or E6 who's listening to this episode, who might be under investigation, and you started to do this, but just a no-nonsense, what is considered sexual harassment under the code, or under the reg, I should say?
So the example I'm going to use at this restaurant is, I'm coming into work. I don't want to deal with this. I want to wait tables. I want to make money. And I want to get out of there. But I have to deal with this person who's making my job uncomfortable. And they're making sexual comments. They're making, gestures, or they're saying things to me, or they're touching me in an inappropriate manner. And I don't want to go into work. That's a hostile work environment, and that is sexual harassment.
So what kind of facts from a military standpoint have you seen where you look at it and you go, you know what? That is sexual harassment. That meets the definition. And let me give you some examples, right? E3 is late to formation. and platoon sergeant says, I don't care if you're a man or a woman, you're going to be here on time every time or you're going to get extra duty. Does that meet the definition of sexual harassment?
Now, that may open you up to an EO complaint, and we can talk about EO on another podcast because that's incredibly broad as well. I don't think that constitutes sexual harassment because there is no verbal comments of a sexual nature.
Okay. How about female soldier goes in, let's say female E4 goes in to talk to first sergeant, and first sergeant says, hey, look, if you're wanting to do well in this unit, you're going to have to start being a little bit nicer to me and doing some more of the things that I like. And it would start with wearing tighter clothes to PT.
That, I think, if it's of a repeated nature or pervasive, because that in of itself isn't, the language isn't severe, because it has to be severe or pervasive. We can kind of, I won't get into the Title IX definitions, but a lot of other definitions. It has to be severe or pervasive and of a sexual manner. So that's kind of a borderline case. So you have to look at it more objectively. And then it goes back to this hostile work environment concept of, would a reasonable person under the same or similar circumstances feel like that is a offensive or hostile work environment? And then is that person actually offended by that?
Last time I want to put you on the spot.
I like your little fact scenarios, by the way, Robert.
Well,
they're actually pretty good.
Some of these are
they're very tricky because I think you could maybe make an argument either way on some of them.
Some of these are actually real life scenarios.
I suspected.
And Sean is going to recognize this last one for sure because it's probably the highest profile case that Sean and I ever worked together. You have a female enlisted soldier who is out in the field for an exercise, and she conducts personal hygiene outside the boundaries of the exercise, and platoon sergeant walks up with a light and says, what are you doing? You need to get back within the actual parameters of the exercise. And otherwise, you just can't leave the prescribed areas for the field. Walks up on her. She's semi-nude. He didn't know that per se. And she's outside the bounds of the parameters of the exercise. Is that sexual harassment?
Is he patrolling?
Sean?
He's patrolling.
He's patrolling. He's covering right now. He's doing patrol of the boundaries of the field exercise and sees somebody outside those boundaries.
So operating on sergeant in the guard duties, right? He has a military purpose for what he's doing.
Correct.
And he's walking between, in this particular case, walking between the shortest points, because why would you be taking a circuitous route when you can go straight? And he tells the person to go back. And then when he comes back, she's still there. And it's been a half an hour. And she's doing something weird. At that point, there's a reasonable expectation that what that person is doing is not reasonable at that point. So that goes back to that reasonableness requirement. In that particular case, there was a other alleged incident that happened several months prior. So then it goes back to the pervasiveness of this. I think both incidents together don't qualify as sexual harassment. I think both separately, they're both different, don't qualify as sexual harassment. But I think the great thing about the sexual harassment policy is there is informal resolution that you can use. And for my example, I just talked to somebody. I was like, hey, you just tell her to knock it off. And that's why I use the informal procedures. But what we have now is they just go for the jungle every single time.
Well, let's talk about why. And then we'll kind of get into Article 134, which is the court-martial stuff,
Correct.
right? Right now, we're talking about the regulations that define what is and what is not sexual harassment. That's oftentimes handled at the investigation, the 15-6 stage or the command investigation stage. So let's talk a little bit about, we have procedures in place. There's a 15-6. The 15-6 officer conducts an investigation and comes back and says the allegation of sexual harassment is founded. What rights do our clients have to attack that allegation, to attack those findings? And if even after our clients respond to those findings, what happens?
So there's different rights for officers and enlisted and for NCOs. Officers, all officers get an automatic right to appeal. I'm talking about commissioned officers, 01 and above, under, I think it's 10 U.S.C. 615 that has incorporated and add the new guidance in 15-6 with the Rapid Act. Even an Army directive, I think it's an Army directive, basically says 01 and above, they get their own right to appeal. But within 600-20, and this is Army specific, but generally you have the right across the DOD on this, is you have the right to appeal sexual harassment, because after that case that we were talking about, and we won't use the name, there was fallout for not investigating accusations of sexual harassment. And there is a very heavy scale to find sexual harassment every single time. So you have the right to an appeal. And in that appeal, that's where, you have to be careful. You have to have your P's and Q's. You have to have everything lined up, and you have to have evidence, depending on what the nature of the accusations. I can kind of get into what some of these accusations are. But you have to be able to, I know the burden's not on us to do this. It's on the investigating officer by preponderance of the evidence. You have to treat it like anything else. You have to convince, I would say beyond a reasonable doubt, with no joke, black and white evidence that this did not happen. And that sometimes you can do that and they'll be like, but she was offended by it.
So, Sean, talk to us about the importance of having an attorney help you if you're somebody who's accused of sexual harassment with that appeal to the investigating officer, because we just read the definition. Mm-hmm. And I talk to guys every day. They're like, well, I think that I'm going to, I can rebut this myself. What's your response to that?
That's a good question. The IO isn't applying the law correctly, the regulation correctly. This presumably at this point has been through a legal advisor who has provided advice to the IO. And when I was, advising, if I was a legal advisor, I would get a copy of the investigation and I would write it out, say, hey, this is what this needs to say. This is what you're trying to say. Is that right? And I would fix it. And then it goes to another legal review where two lawyers have looked at this potentially already and said, this is okay. This is good to go. And you get to the Article 15 or the GOMAR, you get to the appeal, and then they don't even realize that they haven't applied the policy correctly. It's almost every single appeal that I write. I put Chapter 7-7 in because it's literally saying, clearly nobody's actually read this, so here it is, so you have to read it now. And I explain it out.
So let's say soldier, airman, sailor, Marine, submits an appeal, and it comes back and says, yes, this is now unsubstantiated. At that point, the case is likely done, correct? There will be no more action usually taken against the service member. But talk about the mandatory requirements that are now in place, that if there is a founded allegation of sexual harassment, what does the command have to do next?
It needs to go on an NCO evaluation. It needs to go on an officer evaluation. It's mandatory. And they have to initiate separation.
And say that one more time. So just so everybody understands, what did you just say?
They must initiate separation.
Now, is the important word there initiate? And if so, why is that the important word? Does that mean that the soldier, Marine, service members getting separated, or does that just mean, hey, we've got to initiate it?
So in accordance with Army Directive 2022-13, it's an involuntary separation policy. They will initiate involuntary administrative separation proceedings for all soldiers against whom there is a substantiated complaint of sexual harassment, unless the soldier is otherwise punitively discharged or dismissed from the Army, which means through court-martial. So separation proceedings will be processed through the chain of command to the separation authority for appropriate action. It's not mandatory, and they understand that sexual harassment can be anything. So there's a mechanism for rehabilitation. So in your appeal response, when you provide your response, you want to build in, I always have this philosophy, if you can't win, you don't lose. And you always want to go for the win, of course, but you always want to be prepared for the next step, which is setting this up for what's called rehabilitation, which is for a minor substantiated complaint of sexual harassment. The first 06 in the chain of command can make a determination to maintain that particular soldier without going to a board. And there's the criteria for that is you can't be rehabilitated if the offender attempted or engaged in quid pro quo. That's pretty rare. It was a sexual touching offense where the offender was in a superior subordinate relationship, or substantiated complaints involving repeat offenders are not appropriate. So here's the problem. What's a minor substantiated complaint?
And that's my point, right? Is we do have these exceptions for rehabilitation, but I don't think we've hardly ever seen a commander actually go that route. My reading the reg and what I tell folks all the time is, look, it's essentially they're going to move for separation, and almost because they have to if there's a founded allegation of sexual harassment.
I have seen it a few times where they have rehabilitated, and we represented the soldier in question. They have accepted rehabilitation, but it was kind of this, under the table deal is your appeal's not going to be granted. And this is a case where we'll talk about what do you do. I could say you live by the Signal group chat, you die by the Signal group chat. We had the Signal group chat, and she was claiming all this sexual harassment, and it was a hostile work environment. And we've got all these memes that she's sending to this particular soldier saying, like, one of them is like the Splinter meme with the four Ninja Turtles as babies, and then they're adults.
Yeah, so she's actively engaging in the behavior as well.
Not a hostile work environment. She loves the guy, and then she gets in trouble, and then all this stuff happens. Smoking gun. Appeal denied, even though we have all of this stuff. He had to take an NJP, and since he took the NJP, he was allowed to stay in.
Yeah.
So he was getting screwed over, but he was allowed to stay.
But I think it's accurate to say 95% of the time, if not more, if there's the founded allegation of sexual harassment, it's going to lead to the initiation of separation, right? And then at that point, the typical separation board or board of inquiry policies kick in. And so a lot of times I get calls from service members that say, well, they're kicking me out. There was a founded allegation of sexual harassment, and they don't fully recognize, no, that's just the first part of the battle. The second part of the battle, in my opinion, they always have a better shot of winning at, which is the separation board. And we've talked a lot about set boards. But that's the general idea, right? Is that it's going to go to a set board, and then that service member is going to have a whole nother opportunity to present and to fight for their case with a lawyer in a room against the recorder who essentially serves as the prosecutor. And there, the burden of proof is 51%. They've got to prove the sexual harassment happened. And Sean, I know that we had a tremendous amount of success in some recent sexual harassment cases, which we're very proud of. But I'd like for you to touch on one in particular where we represented a highly decorated Green Beret, and talk about what those allegations were against him, and then just spend a few minutes talking about how did you approach it at the separation board, because you had tremendous success and he was retained after a very short deliberation.
So in that particular case, they misapplied the policy in the investigation. The complainant, which is, I don't like to use the word victim, the complainant had said, I don't think it created a hostile work environment. I thought it was just weird and inappropriate. From the investigation comes back founded, gets an Article 15, takes the Article 15. Unfortunately, TDS kind of missed that issue. So I get the case. I'm like, oh, you guys, hey, let's get the appeal in, or let's try to just talk about this. This is what this is. And they say, no, we got to take it. We've got to initiate separation. I'm like, well, this is very clearly minor misconduct. I talk about Army Directive 2022-13. Like, no, we're going forward. And they had actually gotten the complainant to say, no, now that I think about it, 4 or 5 months later, I think it is a hostile work environment. I am offended.
So stop right there. Are you saying, Sean, that initially she said that she didn't think it created a hostile work environment, but lo and behold, after the legal office gets involved, now after 5 months, she says, wait a second, you know what? It was actually hostile.
Yeah. And, that's, so it depends on what community you're in too. And in the Special Forces community, they don't like that.
Right.
And you just, you bring that up on cross-examination. And I'm going to be perfectly honest. A lot of these cases, if the complainant testifies, we're very, very successful in that. And the issue is when the complainant doesn't testify, and it's just your client, going against the void. And so I will say I've been way more successful when the complainant testifies and they are subject to cross-examination than if it's just my guy out there and then the prosecutor's drilling into him. So there's no dichotomy there.
So Green Beret goes to separation board. Informal resolution essentially fails.
Conditional waive,
all that stuff gets thrown out. Just talk briefly, what was your central theme moving into the case? How did you win that case?
Oh, I like I do in every single appeal case, I was like, hey, this is what the policy actually states. And I say, oh, and by the way, here's what Article 134 of the UCMJ states. It says the exact same thing, but in a more clear manner because, judges wrote it. to a certain extent, the judge's instructions. And I say, hey, this is what the standard is. It's comments of a sexual nature. The comments that this particular soldier used were not of a sexual nature at all. They were, potentially inappropriate. And he acknowledged that I probably shouldn't have said that. I didn't know what her rank was, all of that. But the theme is like, hey, this is what this is. It's not sexual harassment. He's been notified of sexual harassment. It's something else. It's not that. And he's apologized. And by the way, he's got 17, 18 years of otherwise stellar service. And, in that particular case, likely saved my life. And I'm providing that testimony. And I know this particular individual. And I know the people who I need to call, just because of the network I have. And I don't leave a stone unturned. I go in and I get the people that he needs I had his battalion commander testify. I had a lot of people testify, hey, this guy's getting screwed over.
Yeah.
And, it's a difficult situation going back to where you say you can't go home again. But I was going back and we talk about, was it the hero's journey or whatever, where you leave and then you come back? I felt like that's what I was doing. And I came in and I was there for, an afternoon or for the day. And then I left again. But I was like, it felt really good to be able to help out that particular soldier, because it wouldn't have happened if I was there. And that's my biggest guilt about leaving the Army, is that some of the stuff I think is happening, and we only see the ones that get to us, right? So there's probably a lot of really great judge advocates there that do recognize this and do kibosh a lot of this stuff at the very, very beginning. But stuff does slip through the cracks. I regret that I'm not there to stop some of this stuff from happening.
Well, I don't regret that, because I'm very happy that you're here with us. And I can tell you that one of the great days that I've had recently was when your client called me, and he was choked up, and he said that he did not think that there was any way he was going to win this case after the Article 15, and that after 18 years of service and I don't know how many deployments, like 6 or 7, something, a very high number of deployments, a lot of combat deployments, that he thought his career was over. And we won that case, and we should have won that case. And I'm grateful for your role in helping that soldier, because that's what we do. That's what we stand for. And a guy like that, 18 years in, Green Beret, operator, we need to protect those people. And if the current legal system is not protecting them, I'm very proud that they have us to call. I know we're coming up towards the end of the episode, and we haven't really had a chance to talk much about the court-martial side of this. But let's just kind of spend the next 5 minutes, Sean, and talk about Article 134. What does it cover? And then we'll talk a little bit about best policies for sexual harassment court-martials.
So it's pretty much the same definition, that the accused knowingly made sexual advances, made demands for sexual favors, made requests for sexual favors, or kind of the broad category, which is engaged in conduct of a sexual nature. Such conduct was unwelcome. And under the circumstances, such conduct would cause a reasonable person to believe, and a certain person, namely, the complainant, did believe that submission to such conduct would be made either explicitly or implicitly a term or condition of a person's job, pay, career benefits, or entitlements. That's that quid pro quo again. Would cause a reasonable person to believe, and a certain person, namely, the complainant, did believe that submission to or rejection of conduct would be the basis for decisions affecting that person's job, pay, career, benefits. Again, quid pro quo, was so severe, repetitive, or pervasive that a reasonable person would perceive, and a certain person, namely the complainant, did perceive an intimidating, hostile, or offensive work environment, with the extra element of it being prejudicial and good or discipline, and or of a nature bring discredit upon the armed forces. Now, what I like about the particular definition here is there's a lot more definitions and explanations of what these things are. And the really key one that I think is really, really important, because we get a lot of innuendo cases where soldiers don't know what before we did the podcast, we were talking about, we didn't know what mewing is. We didn't know what mogging is and what a skibbity toilet is and all that other stuff. Like, we don't know what that is. We'll never know. But you must have actual knowledge that he or she is making a sexual advance, making a demand for sexual favors, making a request for sexual favors, or engaging in conduct of a sexual nature. Actual knowledge is not required for the other elements of the offense. So what I think is really great about Article 134, and what I really emphasize in some of these appeals, is like, hey, this is what this says. Because 600-20, the 10 USC is not, it's very, very broad. And people don't realize the whole thing applies. But when you have the Article 134 and you have these definitions, we've had soldiers being like, man, do they have the big hot dogs or do they have the little hot dogs down at the PX? And this guy's legitimately talking about hot dogs.
Yeah. And
you've got younger crowd, and it's a female crowd, and he's like, man, he's talking about genitalia.
Right.
We've been pretty good about not swearing on this podcast right now.
Yeah, no.
Given the topic of conversation.
We do. I think I've dropped a few curse words over the years. But all right, Sean. So court-martials are happening for sexual harassment.
Yes.
I've personally found that odd because I know of no other state or federal equivalent where you can be prosecuted for alleged sexual harassment. Typically, that's an employee-related issue, right? That's something that is handled through arbitration and civil practice. It's not traditionally something that is handled through prosecutions. We have it in the military. I'm not saying it's a bad idea in the military. We have Article 134 for specific, kind of the catch-all, the general article, right? So that we can enforce good order and discipline. That's important in the military. The military is distinctly different than regular life.
And there was Article 93 as well for cruelty and maltreatment.
Which is funny when President Biden, put into place the new Article 134. I was actually interviewed by CNN about this. And I said, well, I don't really think it's that big of a deal because we've had Article 93 for a long time.
And 92.
And 92. And we've had these issues at court-martials for forever. I used to prosecute them and defend them. But nonetheless, now we have the Article 134. So for our listeners, some of them are judge advocates. Some of them are people being accused. Some of them are just veterans. Some of them are just people that think Matt's great, right? So what are 2 or 3 points, good areas of practice for somebody who's got a client who's facing a sexual harassment court-martial?
Like I said earlier, live by the Signal group or Snapchat messages or whatever it is, die by them. As a rule, this is just for all soldiers, all service members, sailors, Marines, airmen. Just be careful. Know your audience. Don't have a group text, like a work-related group text string, like, hey, this is PT. We're going to be doing a formation at this particular time. Don't send a meme on that one. Know your audience. Have your Signal chat or whatever, and have it distinct. No work-related conversations happening on that. Because that's going to come back to a reasonableness requirement. So if you are knowingly participating in a Signal group chat, sending memes back and forth, a reasonable person under the same or similar circumstances won't say, well, I'm sending memes back and forth of a sexually explicit nature, and I'm sending them, but the fact that you're sending them back to me, I find offensive. A board isn't gonna buy that. A panel isn't gonna buy that. A commander may buy that.
Commander probably feels like he or she has to buy it.
Yeah, an IO will come back and be like, that is of a sexual nature, and you did send it, and they just forget the reasonableness requirement. So remember the reasonableness requirement. Know your audience. If it's somebody that is a little uptight, just keep it professional. And that's ultimately what you have to do as a soldier and you're, as a service member. Be professional. The issue is that you get so close to everybody when you're deployed or in the field. Like, you start these really, really close relationships and you confide with one another about, hey, I know when I was deployed, like, I would have conversations about my relationships all the time.
Right.
And, sometimes they would veer into conversations of a sexual nature. I knew my audience. I knew I was talking to. And I know what I say, and I recommend that soldiers and service members do is, hey, is it okay if I talk about this? And they'll say yes. And then if they say afterwards, like, well, I asked if it was okay and there was no pressure. I'm like, I wanted to make sure. And you just be very clear and be very honest. And it goes back to what we learned at the Trial Lawyers College. Go back to that Common Core experience of, what would a reasonable person, what do I feel in this situation? We've all been deployed. We've had these conversations at a bar where you're upset, or something's going on, and you just need somebody to confide in. That's not sexual harassment. That is having a conversation. That's being there for somebody. And just because you get in trouble, or you're not happy with work, or you didn't get the assignment, or you think that somebody else is being treated more fairly, that's not sexual harassment. It really has to come back to this idea of the hostile work environment. Quid pro quo. We don't see
that very often.
But the hostile work environment, I don't want to come into work. So I don't want to deal with this person. I don't want to deal with them making sexual comments about my body, making finger gestures and stuff like that, or, whatever it is. That's unacceptable. And I'm not going to say the Army doesn't have a problem with sexual harassment. I think it does, actually. But the problem is that, as with all things in the Army, they have a problem. They recognize the problem. and then they annihilate the problem, and they do not care about the collateral damage that happens in that. And so that's where I come in, and I'm just like, all right, as a national security law attorney for a long time, I care about collateral damage. I don't want innocent people caught in what's supposed to capture inappropriate things. So if you send a naked picture of yourself, or you send a very explicit meme to an E3 and you're an E7, guess what? You're going to get founded. There's nothing I can do. I can try, by the way, but there's actual sexual harassment. And then there's this, I feel that he looked at me in a glaring manner, and it was done in a sexual manner. And then he moved his mouth up and down when he talked to me. And I felt like I could see his tongue move back and forth.
And
like,
people
see that.
Right. People are listening right now thinking, no, that doesn't.
Yes, it does.
We get all kinds of stuff that's like, oh, I could tell by the way that he was doing his push-ups that he meant to harass me with them in a sexual manner. And the IOs buy that stuff. They're like, oh, if this person, he or she, feels harassed, then that is sexual harassment. But I want to conclude here in a few minutes. I want to add some free advice to our listeners. And this is mostly to our males out there that serve. Typically, we see it in the E5, E6, O1, O2, O3 categories. Listen, gentlemen, the female soldiers that you serve with are your brothers and sisters in arms. They're not your dating pool. The biggest mistake that we see, that I see on a daily basis, is folks treating the primarily the female service members they serve with as a dating pool. And that is absolutely not the right answer. And I see so many times where even if the relationship starts off as consensual, even if it starts off as a real dating opportunity, the second something goes wrong in that relationship, it turns into sexual harassment. So guys and gals out there too, look, you have a lot of opportunities to date folks. Don't date the folks that are in your chain of command. Don't date the folks that you're serving with every day. They're not your dating pool. It's just bad news bears. And Sean, I hope you agree with that advice, but I know we're up against the end of it here.
Yeah,
so,
to end on that, think these women, these soldiers, these service members get bombarded with comments, and you don't want to be the person. You don't want to be the straw that breaks the camel's back.
That's right. And if you find yourself in a position where you're accused of sexual harassment, call us. We offer free consultations. We will help you. And this is what we're here to do. And we've been doing it at a high level for a long time, and we're very passionate about it. And I tell people all the time, it's not just the practice of law at Capovilla Williams. Defending our service members is really our mission. That's what we do every single day. I don't think there's a firm out there that knows this stuff better than we do. Give us a call. You'll get a free consultation. We'll be happy to help you. And here's the other thing. We're going to be very honest with you about your chances, about your cases, about the situation, and about the law. So I'll turn it back over to Matt to close us out. But Sean, I thought that was really well done. I think your knowledge, your depth of knowledge, your breadth of knowledge, and your experience are really second to none, and I appreciate you.
All right. Well, let me jump in here. I do have a question, though, because I'm obviously the non-military person here at the table. But are there exceptions to any of these things? As somebody who hasn't served, I look at, we get our information from the movies, right? So I think of Full Metal Jacket and the boot camp in Full Metal Jacket where they're training and the drill instructor saying all kinds of stuff to the guys early in the movie. Does that stuff still happen, or has that now been eradicated because of these policies? Because clearly there's a lot of things that is said there as an example that would be, I think, certainly sexually in nature and disparaging and create a hostile work environment. So are there exceptions during training, or have instructors really been told and forced to eliminate that from that part of it?
So recruits and trainees, the Department of Defense has very clearly recognized that this is a vulnerable population. They're young. They're in an environment where they're away from their families sometimes for the first time. And these drill sergeants have a position of authority. So it has, for the most part, been eradicated. And it's taken very, very seriously when you have any type of things. They take it very, very seriously. You get this sharp training from the very, very beginning in the Army, to the point that we get these soldiers and these service members that come out of basic training or out of AIT, and it's like Chicken Little. Everything is sexual harassment. So that's kind of what we're dealing with now, is they get bombarded with it. But to a certain extent, they need to be protected at that level, given some of the stuff that's happened in some of these training commands in the past. So I think that it has been eradicated. I mean, I've heard stories from drill sergeants about some of the stuff that they said to some of their trainees, and I will not say it, but I will tell you afterwards what they would say. But like, that's been gone. That's old Army. I know we get frustrated with the sexual harassment problem, the sexual harassment, the way that's been adjudicated, but there was a problem. I think there is no question that there was a problem, and it's inappropriate. Nobody should have to go to work and feel uncomfortable about anything going into work. It's supposed to be a job about defending our country. You don't have to be you don't need to be worrying about defending yourself from somebody who's being inappropriate with you, and you don't want to deal with that. It sucks.
Yeah,
it sucks.
Well, great episode, and I echo what Rob said, Sean. Your knowledge of this stuff is awesome, super deep, and we appreciate you coming on the podcast today. Obviously, you'll be back in the future, but until that time, we're going to sign off. Thank our listeners. Take care, everybody. Be safe. We'll see you next time on the Military Justice Today podcast.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.